All right, welcome in everyone to another deep dive. Today we're wading into the waters, well, maybe more like the deep end of the pool of business law. Specifically, we're going to try to understand this thing called a convenio concursal.
No.
Now, I know, at first glance it sounds about as exciting as reading the fine print of your car insurance policy, right?
Yeah, I can see that.
But stick with us, because this is actually one of those legal mechanisms that once you peel back the layers, it's actually pretty clever.
Yeah.
It's basically how businesses on the ropes, like really facing financial trouble, can sometimes manage to get a second chance without everything instantly going up for auction,
Right. Great.
It's all about striking a deal, a high-stakes negotiation between a company and the people they owe money to.
Absolutely. It's a crucial window into how businesses, especially those in dire straits, can navigate these really choppy financial waters. And for this deep dive, we're pulling our insights from MCHM Abogados, a law firm based in Almeria, Spain. They work with everyone, individuals, companies, even public entities. So they've got this really broad view of the legal landscape, which is super helpful for us.
Yeah, for sure.
And they're all about finding effective, practical, legal solutions.
Okay, that's good. Not just theoretical stuff.
Exactly, real-world stuff.
So that's a perfect lens for us to really unpack this whole convenio concursal thing, right?
Absolutely.
So what we really want to do today is kind of cut through the legal jargon and figure out how this convenio concursal actually works, in practice. Like, what are the different ways these agreements can be structured? How do they actually get approved? What happens afterward? And this is the part that kind of blew my mind when I was reading up on this, why this whole process is often better for both sides, both for the company that's struggling and the people they owe money to. It's like counterintuitive, So let's start with the basics. What exactly is a convenio concursal? Like, if you had to explain it to someone who's never even heard of it before.
Okay, well, in the simplest terms, you can think of it as a formal agreement, a contract, really, between a company that's on the verge of going bankrupt, meaning they can't pay their bills.
Right. They're in trouble.
And the people they owe money to, those are the creditors. And the key here is formal. This isn't just a handshake deal. It's got to be approved by a court to be official, legally binding.
So it's not just wishful thinking, hoping everyone will play nice.
No. There's a whole legal process involved.
So if a company's in this position, right, why even bother going through all these hoops? What's the point of trying to get this convenio concursal? What's the goal?
Well, the main goal is to come up with a new plan, a new set of rules for how that struggling company will pay back its debts.
Right.
And this often involves something called quitas, which means reducing the total amount of debt.
Oh, interesting.
And esperas, which means extending the deadlines for payment.
So it's kind of like hitting the reset button, but in a way that's like official and legal.
Exactly, yeah. And the big idea is to restructure everything so the company can actually stay in business and hopefully eventually get back on its feet financially.
So it sounds like the creditors, the people who are owed money, they might have to accept less than what they're owed, or wait longer to get paid back. So why would they ever agree to that?
That's a great question, and it really gets to the heart of why this whole system exists. See, the alternative to a convenio concursal is usually liquidation, which is basically like selling off all the company's assets piece by piece.
Right, like a fire sale.
Exactly. And here's the thing. In a liquidation, creditors often end up getting back even less money than they would if they agreed to a well-structured convenio concursal.
Oh, so it's like cutting your losses strategically.
Exactly. Liquidation can be messy and expensive, and selling things off in a hurry rarely gets you the best price.
Yeah.
So a convenio concursal, even though it might involve some compromise up front, can actually be the better bet in the long run.
Huh. That's fascinating. That what seems like the less appealing option for creditors can actually be the smarter financial move. Now, you mentioned that there are actually two main types of convenio concursal.
Yes, that's it.
Can you break those down for us?
Sure. You've got the propuesta anticipada de convenio, or PAC-E for short.
Okay, a PEC.
Which basically means an early proposal.
All right.
And then you have the convenio ordinario, which is the standard, more common type of agreement.
Gotcha. So the main difference is when these proposals happen in the whole insolvency process.
Precisely. The PAC-E, as you might guess from the name, is put forward much earlier.
How early are we talking?
We're talking right at the start, basically.
Ooh, right out of the gate.
Yeah. A company can propose a PAC-E from the very beginning of the insolvency proceedings.
Wow. Okay.
And they have until the end of what's called the credit communication period to do it.
And what is that, the credit communication period?
That's when all the creditors officially tell the court how much money they're owed.
So it's like laying all the cards on the table?
Exactly. So the panic is all about trying to get ahead of the game, putting a restructuring plan in place quickly.
Proactive. I like it. But is it harder to get a PAC approved since it's so early in the process?
Yeah, there's a bit of a higher bar to clear.
Okay.
To even get the judge to look at a PAC.
Yeah.
The debtor, the company that owes the money, needs to already have some support from their creditors.
Like how much support?
They need at least 1/5, so 20% of the total debt they've declared to be on board with the PAC.
So it's like showing the court that, hey, this isn't just us, we've got some serious backers already.
Exactly. Without that initial buy-in, a PAC is likely to go nowhere.
That makes sense. So let's say a PAC does manage to get that 20% support and the judge is willing to consider it. What happens then?
Well, the next step is that the PAC gets handed over to the insolvency administrator.
And who's that?
This is basically a neutral expert appointed by the court to oversee the whole insolvency process. They're like the referee, making sure everything's by the book.
Okay, makes sense.
And their job at this point is to really examine that PAC to see if it's realistic.
All right.
Can the company actually stick to the proposed repayment plan? Is it fair to all the creditors involved?
Right, so no one's getting a raw deal.
Exactly. The administrator acts as a kind of safeguard to make sure the early proposal has a legitimate chance of working.
All right, that makes sense. So that's the PATICO, the early bird option. What about the other type, the convenio ordinario? When does that come into play?
Well, the convenio ordinario comes later, after what they call the common phase of the insolvency proceedings. That's basically when everyone figures out exactly who's owed what.
Right, like taking inventory of the whole mess.
Yeah, exactly. You got to get a clear picture of all the debts before you can start talking about how to restructure them.
Right. So with the convenio ordinario, does the company just present its proposal to all the creditors?
Yeah, that's right. But here's the key difference from the PATIC.
Okay.
Instead of needing that upfront support, the proposal has to be approved by a majority of the creditors at a big meeting.
Oh, okay. So it's like a more traditional vote.
Yeah, you could say that. This meeting is called the Junta de Acreedores, which just means creditors meeting.
So everyone gets together, or at least they're represented, and they hash it out, right?
Exactly. It's a high-stakes negotiation where the company's fate is literally on the line.
Now, I'm curious, who actually gets to put forward a proposal? Is it always the company that's in trouble, or can the creditors also propose something?
You know, that's one of the things I find so interesting about this whole process. The proposal can come from either side.
Really?
Yeah, the debtor company or the creditors themselves.
Huh. So the creditors might actually be the ones saying, hey, let's work something out.
Absolutely. Because remember, they have a big incentive to avoid liquidation, too.
Right, right. Everyone loses in that scenario.
Exactly.
So whether it's the company or the creditors who come up with the proposal, what does a convenio concursal proposal actually look like? What needs to be in it?
Well, first and foremost, there's got to be a detailed payment plan. This lays out exactly how the company is going to pay back its debts, even with the restructuring.
So like how much they'll pay, when they'll pay it, all that stuff.
Yeah, all the nitty-gritty details. And of course, it'll include any reductions in the debt, the quitas, and any extensions to the payment deadlines, the esperas.
Gotcha. So it's not just about promising to pay, it's about showing how they'll actually do it.
Right. And sometimes, especially for larger, more complex cases, the proposal might also include what's called a viability plan.
Okay. What is that?
It's basically a roadmap for how the company is going to turn things around.
So they're not just asking for a break, they're saying, here's how we'll get back on track.
Exactly. It's about demonstrating a commitment to becoming financially healthy again.
All right, so let's talk about this creditors meeting, the Junta de Acreedores. Who actually calls this meeting?
That would be the judge who's overseeing the whole insolvency case. They set the date, time, location, make sure everyone knows about it.
So they're kind of like the event planner, in a way.
In a way, yeah. But it's a pretty serious event.
Yeah, for sure.
This is where the fate of the company is decided.
So what actually goes down at this meeting?
Well, the proposed convenio concursal gets presented.
Okay.
All the creditors get a chance to ask questions, air their grievances, all that. And then the big moment. They vote on whether or not to approve the agreement.
It's like a courtroom drama, but with money instead of, jail time.
Right, right.
So how does a voting work? What does it take to get a convenio concursal approved?
Well, generally speaking, you need a majority of the creditors who are at the meeting, or at least represented there.
Okay, a simple majority.
But, and this is crucial, the majority also has to represent at least 50% of the ordinary debt.
Ordinary debt, what does that mean?
That's the unsecured debt, the kind without any collateral backing it up.
Okay, so it's not just about the number of creditors, it's about how much money is actually at stake.
Exactly. This makes sure that the creditors with the biggest exposure have a say in the outcome.
Right, so it's fair to everyone.
Yeah.
So let's say the creditors vote yes. They approve the convenio concursal. Is that the end of the story?
Not quite. There's one more step. Judicial ratification.
What does that mean?
The judge has to give their final stamp of approval. Even though the creditors have agreed, the judge still needs to review everything.
So it's not just a rubber stamp?
No. They have to make sure everything was done by the book, that the voting was legitimate, that there are no legal loopholes.
So they're like the quality control manager?
In a way, yeah.
And do they also look at whether the convenio concursal is actually feasible, like if it's actually going to work?
Yes, absolutely. The judge has to be convinced that this agreement gives the company a real shot at getting back on its feet.
So it's not just about legality, it's about practicality, too.
Exactly. The judge is the final safeguard, making sure this isn't just a temporary fix that's going to fall apart in a few months.
Right. It has to be a sustainable solution.
Precisely.
Okay, so let's assume the judge gives their approval, everything's signed, sealed, delivered. What happens then? What are the immediate effects of this convenio concursal coming into force?
Well, one of the most important effects is that the liquidation process stops.
So the company's assets aren't going to be sold off?
Nope. The convenio concursal puts a halt to all that.
That's got to be a huge relief for the company.
Oh, absolutely. It gives them breathing room, a chance to regroup and get back to business.
And what about the debt itself? What happens to that?
That's the second major effect. The debts are restructured according to the agreement.
So the reductions, the extensions, all that comes into play.
Exactly. The convenio concursal basically rewrites the company's financial obligations, giving them a fresh start.
So the burden is lighter, hopefully manageable.
That's the idea.
Are there any other protections that kick in for the company once the convenio concursal is active?
Yeah, there's a pretty important one.
Okay.
As long as the company is sticking to the agreement, following the new payment plan, they're generally protected from any new legal claims from the creditors who are part of the convenio.
So they can't just come back and demand more money?
No, not as long as the company's holding up its end of the bargain. It's all about creating a stable environment for the company to recover.
Right, like giving them a fighting chance.
Exactly.
Now let's zoom out a bit and think about the advantages of this whole convenio concursal thing, for both the company that's in debt and for the creditors. We've talked about how it can be a better financial outcome for creditors than liquidation. But for the debtor company, what's the biggest win?
Well, the biggest win is simply survival.
Right, staying alive.
Exactly. A convenio concursal gives them a chance to avoid complete shutdown, to keep the lights on, keep people employed.
And beyond just surviving, are there other tangible benefits?
Oh, tons. Avoiding liquidation means they get to keep their assets, which are often essential for their business.
Right. It's not just about the money. It's about the tools they need to operate.
Exactly. And it also allows the people who know the business best, the owners, the managers, to stay in charge and steer the ship towards recovery.
Okay, so it preserves the expertise, the institutional knowledge.
Precisely. It's not just about handing over the keys to someone else and hoping for the best.
Now, switching gears to the creditors. I know we've talked about how a convenio concursal can often lead to better financial recovery for them in the long run, but are there other reasons why they might prefer this to just forcing a company into liquidation?
Yeah, there are a few other advantages to consider.
Okay.
For one thing, a convenio concursal is usually a much faster process than liquidation.
So they get their money sooner, even if it's a bit less?
Potentially, yes. And it's also generally less risky.
How so?
Liquidation is a bit of a gamble.
Okay.
You never know exactly how much you'll get back.
Right. It depends on how much the assets sell for.
Right. And that can be unpredictable.
So a convenio concursal is more like a sure thing, even if it's a smaller sure thing.
Yeah, you could see it that way.
So overall, it sounds like this convenio concursal, when it works, it's a more, a more elegant solution than just shutting a company down.
I think that's a good way to put it.
It's a chance for a reset, for everyone to take a breath, figure things out, and hopefully move forward in a positive direction. It's like acknowledging that sometimes businesses hit a rough patch, and that doesn't mean it's the end of the story.
Exactly. It's recognizing that there's value in giving companies a second chance, not just for the company itself, but for the employees, for the creditors, for the whole economy.
Right. It's like a ripple effect.
Exactly.
So to sum all this up, the convenio concursal is this legal tool that lets struggling businesses negotiate with their creditors. to try and come up with a new payment plan that works for everyone. It can involve debt reductions, payment extensions, all under the supervision of a judge. And the goal is to avoid liquidation, to give the company a chance to recover, and to give the creditors a better shot at getting at least some of their money back.
That's a great summary.
So what I find really fascinating about this is that it's not just about saving one company. It's about recognizing the bigger picture, the interconnectedness of things. It's saying that a healthy economy needs mechanisms like this, mechanisms that acknowledge that failure isn't always the end.
Right. It's about finding ways to mitigate risk, to allow for some degree of failure without it being completely catastrophic.
Exactly. Because if businesses are too afraid to take risks, if they know that one misstep could lead to total ruin, then innovation suffers, right?
Absolutely. I think that's one of the most important takeaways from this whole discussion.
It's not just about the legal technicalities. It's about the philosophy behind it. The idea that a healthy economic ecosystem needs to allow for some level of failure.
And that there are ways to manage that failure, to turn it into an opportunity for learning and growth.
Exactly. So if you're out there listening and you're thinking about starting a business or even just taking a big risk in your career, remember that the legal landscape isn't always about punishment. Sometimes it's about providing safety nets, second chances.
Yeah, it's about creating a space where calculated risks can be taken, where failure isn't a death sentence.
Absolutely. Now, if you're hungry for more information on this, and I know I am after digging into all this, our source for this deep dive, MCHM Abogados, they've got a ton of expertise in this area. They're based in Almeria, Spain. You can find them at Calle Santiago Vergara 20, postal code 04008. Their phone number is 950-106-453. And if it's an emergency, you can reach them at 674-221-6559 or shoot them an email at info@mchmabogados.es.
They're a great resource for anyone who needs legal guidance on insolvency and restructuring.
All right, that's it for our deep dive on convenio concursal. I don't know about you, but I'm feeling a lot more informed.
Me too. It's always fascinating to peel back the layers of these legal mechanisms and see how they work in practice.
Absolutely. Thanks for joining us, everyone, and we'll catch you on the next deep dive.